We're so happy you've joined today's Lunch and Learn, following the digital breadcrumbs, identifying, preserving, and presenting digital evidence of stalking and other crimes. I am your host, Sherry Curticle, CEO of VictimsVoice. Today's program is being sponsored by the DVA Center. The Domestic Violence Advocacy Center provides education prevention services, court advocacy, confidential services and support to teens, young adults, and adults, including family and friends who are exposed to or experiencing domestic violence. When one hand reaches out, 100 hands reach back. Stay strong, stay safe, stay connected. This session is being hosted by VictimsVoice, creator of the VictimsVoice app, the only legally admissible documentation tool that allows victims to safely, securely, and privately store the evidence-based details needed for stronger prosecutions, better investigations, and more appropriate prosecutions. VictimsVoice, giving victims a legal voice. For more information about our partner program, visit us on the web or through our social channels as shown here. Today's program will be delivered by Jane Anderson and Dana Flightman. Jane Anderson brings her expertise in prosecuting domestic violence, sexual violence, and human trafficking to her role as an attorney advisor with Equitas. Prior to joining Equitas, Jane served as a prosecutor in Miami, Florida, where she tried many of the state's first human trafficking cases. In her role as a founding member of the Human Trafficking Unit, Jane developed policies to better identify and provide necessary services to trafficking victims, while ensuring offender accountability through the use of digital evidence and creative charging decisions. Jane also served as a supervisor in the Domestic Violence Unit, where she trained new attorneys and oversaw the prosecution of domestic violence, stalking, and violations of protection orders. Throughout her career, Jane prosecuted felony-level crimes of all types, including homicide, kidnapping, and sexual assault. Dana Flightman is the Training and Awareness Specialist for SPARK and has been with the Stalking, Prevention, Awareness, and Resource Center since 2018. In this role, she provides in-person workshops, online training, and technical assistance to multidisciplinary professionals across the country on recognizing and responding to stalking. Dana develops resources, curriculum, and publications on stalking and leads SPARK's National Stalking Awareness Month efforts each January. Prior to joining SPARK, Dana was the Senior Manager of Prevention and Training Programs at Jewish Women International, the leading Jewish organization working to end violence against all women and girls. Her work at JWI included creating, delivering, and managing multiple educational programs on interpersonal and sexual violence for audiences ranging from teens to campuses to professionals in the field. She also wrote and supported federal and foundation grants and coordinated a monthly webinar training program for domestic violence service providers. Dana's previous experience includes coordinating training and technical assistance for the Health and Human Services Office of Adolescent Health Teen Pregnancy Prevention Grantees. She also has direct service experience with groups including foster teens, refugees, and recent immigrants. I am very pleased and excited to turn it over to Jane Anderson.
Thank you so much for having us. Let me share my screen because we're going to be talking today, this Lunch and Learn for following the digital breadcrumbs, identifying, preserving, and presenting digital evidence, and other stalking and other crimes. And, we don't have a lot of time, so we're going to try to get through this and make sure that you have as much information as possible. So we're supported and we're really happy to be here. Thanks to the Office of Violence Against Women, the Department of Justice. They grant fund us to provide training such as this. And we always strive to make sure that you guys have the best information possible, which means that we'll be sharing work that was created by others. And we do that under the fair use. And that includes some research and best practices and things like that. So I'm Jane Anderson. That was probably the best reading of my bio ever. I have to let you know that. Thank you so much for that. You guys got a good sense of who I am. I've been working with Equitas for about 7 years now, and I love being able to help others in the field learn from maybe some of the missteps that I had when I was a prosecutor, also some of the successes that I had. And we are partnering with Spark today and Dana, and want you guys to learn a little bit more about their resources that you can find online. Dana?
Yeah, thanks so much, Jane, and thanks to Sherry and for everyone for joining. So Spark, the Stalking Domestic Awareness and Resource Center, is a proud project of Equitas, and our website is stalkingawareness.org. So like Jane said, at least for us, we're very spoiled. We're used to giving these long presentations, so we're really trying to keep it moving. So what we hope is that after this, you'll be interested in learning more from us. And the great news is that because we are the national training provider, you can follow up with us anytime we could provide additional training. Because, you know, when it comes to stalking, a lot of times it's sort of that forgotten extra crime. And there's 4 major crimes under the Violence Against Women Act. It's domestic violence, sexual assault, dating violence, and stalking. But it's always kind of and stalking, like we almost called our website andstalking.org. It's a crime that is prevalent and that the victims and survivors and offenders you're working with, depending on your role, are definitely participating in and affected by. So we have practitioner guides. Those are broken out by discipline. So we have for law enforcement, for prosecutors, for victim services, for awareness educators. We have scripted training modules if you do any kind of public awareness education that you could just pick up and lead. We have victim resources, so we are not a direct service provider, but we do have things like brochures and just general information that can be helpful that you can share with victims, and webinars like this one. We have a bunch in our archives on our website. We're also on social media. Our handle on there is at Follow Us Legally. If you get our sick sense of humor at Spark, if not, it'll be a long hour for you. So really your call either way. But I hope that you will follow us and sign up for our newsletter. As a anti-stalking organization, we do not automatically sign people up for unwanted contact. You have to opt in. So I hope that you'll do that. We only send it about quarterly. So that's my quick launch Spark, and I hope that you'll be in touch.
And we are at Equitas really proud of our partnership with Spark and the great work that they're doing. Equitas has been around since about 1999, and we are funded through federal grants and some private grant funding, really just to provide those that are working in this field with the most up-to-date, most practical strategies possible. So we're all former prosecutors, and hopefully there'll be something that you learned from today that you can immediately put into practice. And we, of course, are also available online. We have lots of webinars and additional training, but let's get to it. So today we want to kind of focus on a few things. One is identifying how offenders are misusing technology to stalk, but also to just assert power and control if we're looking at maybe a domestic violence relationship.
Okay, so like Jane was saying, our objectives here, all right, so coordinate with allied professionals to better identify and preserve sources of digital evidence. We know that victims come to our system from different entry points, and we want to make sure that it's not just our prosecutors who understand how to identify and preserve that evidence. We want to empower victims to do some of that themselves, because naturally when a victim receives, say, an upsetting text message, for many of them, their instinct is to delete it because it was upsetting. And so we want to educate our victims as well as other responders that they might be working with on how to better preserve that and not do that. And of course, presenting digital evidence in court, recognizing that the court may or may not be familiar with the kind of technology being used or misused in these cases. And so how do we get that admitted? And so I know Jane will give you some good big picture tips on that. And you can definitely follow up with Equitas for a deeper dive. So let's consider technology facilitated abuse. And I'm curious if you can let me know in the chat, how have you seen technology misused to perpetrate stalking, domestic violence, or related crimes? You know, what have you seen happen? And so my guess is that you've seen all sorts of things. I work on stalking specifically, and we know that while most people who are engaging in stalking behavior do so both online and in person, most are doing both. They're not just online, they're not just in person, they are using those technologies to enhance their in-person behaviors. And so I'm seeing some things here, this adding apps on phone to track text, emails, etc. Yeah, that could be stalkerware. That could be in some way accessing, say, their cloud or their Google Drive backup to see what that person's been doing. The map on Snapchat and Life 360, yes, absolutely. We have that stalking through social media. Sometimes folks aren't aware of what they're sharing about themselves, or sometimes they just don't think someone will misuse it in that way. So monitoring on social media to see where somebody is, where they've checked in, who they're hanging out with. Adding tracking devices, absolutely. So that could be an external GPS device, like something put on a vehicle or in a purse. It could be misusing something like Find My iPhone or a family sharing plan or something like that. Hidden cameras and GPS trackers. Yeah, cameras have been around a long time and recording devices, but they're getting smaller, less expensive, and more high definition. And where you perhaps used to have to go retrieve a little VHS or something, now they're often streaming to a remote location. So yeah, and challenge by people using spoof numbers. Yes, just for those who aren't familiar, spoofing is just making a call or email look like it's coming from someone else. So the victim knows not to talk to the offender. It says mom's calling, they pick up the phone and it was the offender. So yeah, all of these and more. Of course, it can go on and on and on, misusing these different kinds of technologies. Whew. So when we look at the misuse of technology, we see how that feeds into the power and control dynamics. And it also can be criminal. Sometimes these intersect and sometimes they don't. From a victim safety perspective, we care about both. And so it can be quite confusing to untangle this with our victims and survivors, right? Because we want to identify the victim safety issues from that power and control, and also try to identify some crimes that we might be able to charge and have some amount of accountability for there under those criminal acts. And so, you know, when we look at stalking or domestic violence, it's a pattern of behavior. It's a series of events. And so it's always what's happened before, what's happening now, what might happen next. And so if we think about technology, there are so many ways it can be misused. And you know, we like to say the problem isn't the technology. It's easy when you list, like you all just did, all these terrible ways that, you know, technology can be misused, that we might start to really hate technology if we don't already. But the reality is that technology doesn't cause stalking or domestic violence, right? These offenders cause stalking and domestic violence. It is their use and rather their misuse of it. A lot of the technology itself is neutral. A camera can be used to take a non-consensual photo or video of a survivor. It can also be used to catch an offender breaking into the home. And now we have great evidence. And what used to maybe be an in-person conversation that would be hard to prove later, well, now that's more likely to be a text message. And we actually have that evidence and that documentation, right? And so it can be really helpful in a lot of ways, both for victim safety. And I often find it is stalking survivors in particular who really like using those technologies, who like to have a camera in their home, who like to use a smart device and have the lights come on before they come in, right? So it can be protective as well. And we know that the technology is how, you know, most survivors find services, connect with others. We certainly, if we didn't know that before the pandemic, we know it now, how critical technology is to keep us connected, both professionally and socially. And so absolutely, technology can be really, really helpful in all of those ways. So sometimes we hear folks say, well, change your number, get off, don't use that technology. But you know, the truth is that victims have a right to technology. It can be helpful, and it's really understanding the use and the misuse that can be the problem that we want to focus on. And with that, I see Jane has returned, so I will hand it. Well, actually, I'll do a couple more, and then I'll hand it back to her. Is there anything? Well, I'll just keep going, I guess. So that being said, as much as I'm saying, hey, technology is not the problem, it can certainly enhance or facilitate a lot of harmful behaviors. And many of you mentioned these in the chat. It can be used to monitor, so that's where you get that GPS, camera, watching, seeing where the victim might be. And then we have that enhancing those in-person behaviors, right, when it comes to stalking. So, okay, I'm monitoring you on GPS, and now I'm going to show up where you are and follow you. Harassment and messaging, we know that we see these platforms used quite often for that. So messaging through social media platforms, email, phone calls, etc. Control, so that you better send me a check-in when you get somewhere, putting that GPS on the vehicle, why'd you go there, right? And so finding ways to kind of catch that person, as well as just demand their attention all the time. The victim's just trying to get through their day, and there's constant texts, emails, messages from that offender. It's really hard for them to get on with their day and live a normal life. Of course, instilling fear. And it's scary to think that you're being followed, right? That someone is watching everything that you do on your computer or on your phone. Absolutely, it's scary. We also see threats communicated directly through technology, of course, right? That I will harm you, I will do this to you. As well as threats that are contextual in nature, like somebody sending a photo of themselves in the victim's home to the victim. Very scary, instilling fear, right? Absolutely. And embarrassment. We see a lot of spreading rumors through technology. So that could be through rumors about what that person likes sexually. It could be impersonating them online. We see quite a bit of that. So impersonating them on, say, a dating website, and then pretending to be them and saying, hey, here's what I'm looking for, and here's what I'm into. And so all of these can cause different kinds of harm. It can be through the non-consensual distribution of intimate images, which I know Jane will talk about a little bit more later. So really across the board, it looks like from what you put in the chat, you've certainly seen how technology can enhance or facilitate just about every kind of abusive behavior and controlling behavior.
But there are some challenges to technology, which we've sort of all experienced today a little bit. But furthermore, when it comes to how it intersects with the criminal justice system, we have sort of a patchwork statutory scheme. In all 50 states, it looks a little bit different, but there isn't one statute that sort of addresses all of these things. And so we need to figure out what's in our toolbox. And how to use that. And because some of the laws have been recently enacted to address, changes in technology, we've got a little cat and mouse game going a bit. And those laws that have been enacted recently to address some of these things, they are not tested, right? There isn't going to be a string of case law, and that makes prosecutors nervous. And so they might be less likely to want to pursue charges when nobody's ever tried that case before in their jurisdiction. There's no case law for them to look at. There's nobody in their office that they can go and knock on the door and say, hey, how do I do this? And so this is a practical challenge. And then we also have the challenge that is as things change, the laws don't quite keep up. So there was a string of laws that was all about, sort of peeping Tom laws and video voyeurism. And then it never addressed the fact that now cameras are so small that there were offenders that were putting cameras on the top of their shoes and putting them under girls' skirts as they were going up escalators in the metro or in the mall. So we refer to this as upskirting. Well, because it was happening in a public place like a mall or a subway, the law actually did not address that, because the laws were written that this sort of video voyeurism was only illegal if it was happening where the victim had an expectation of privacy. So it meant to be like locker rooms and bathrooms. And all of a sudden it was happening, in public, and the law wasn't addressing it. And so a lot of states have actually had to go back and rewrite those laws to address this upskirting phenomenon. So we have to kind of keep up all the time. The rules of evidence about how to put something into evidence in court, those were written decades and decades and decades ago, before anyone contemplated, oh, I want to admit a Snapchat, or I want to even admit text messages. So we've got to sort of fit the laws with our current technology, and that can sometimes be a challenge. These are some of the most common charges that are related to this sort of misuse of technology. And this doesn't cover everything, and every state's a little bit different, but these are the places that I always encourage prosecutors to look at, and law enforcement as well. And some of them are going to be things that you think of, but some of them might be a little bit less commonly thought of as related to the misuse of technology and intimate partner relationships. So for example, extortion. Very often we're hearing about sort of this blackmail type, I have these incriminating photos, or I'm going to tell your boss about something or your family about something, that actually can be charged under most extortion statutes. Identity theft is another one that's sort of less commonly thought of, but identity theft can usually be charged in any case where somebody is impersonating somebody online, using somebody's login to get onto their Facebook. So we know in controlling relationships, oftentimes the offender will require that the victim, provide all of their passwords. And so then the offender can go on and, using their passwords, go onto their Facebook and make some of those statements that Dana kind of talked about. And that can be charged as identity theft. And identity theft is one of those crimes where you can charge every single time that they get onto your Facebook. And after a while, that ends up becoming a felony. So we want to be thinking about ways to really hold the offenders accountable. And some of the ways to do that is to charge these multiple charges or to stack them, because otherwise most of these are going to be misdemeanors, right? And thank you, Mandy, for pointing this out. Misuse of a communication device. I don't know if you're also from Florida, but I prosecuted in Florida, and that was something that we could use nowadays, almost every crime we could use it, because there was some sort of evidence of a cell phone being used. And so that was another way to sort of get to the point where we're really holding offenders accountable.
Yeah, I just wanted to add too that, especially with stalking cases, they're not unique to stalking cases. We often hear victims say, I was told they couldn't do anything because no one had hurt me yet. We hear that all the time. And the truth is there are plenty of non-violent, explicitly violent crimes that can be charged. And so if you can't hold that offender accountable for stalking or domestic violence or battery, hold them accountable for something, right? And so we really encourage you to think creatively about the charges, both the technological and otherwise, because even something that seems really minor, like harassment using a telephone, for example, that's a crime in a lot of jurisdictions. And so with stalking, where you're trying to build up a course of conduct, right, it's more than one thing. Even if it seems really minor and someone's saying, okay, someone prank called you, what's the point of charging that? You're helping that person next week, because next week when there's video voyeurism, I know I'm not your judge, but according to me, Judge Dana, you have a stalking case. You have 2 or more behaviors that would make someone feel afraid, right? But if we didn't really think about that first thing, that harassing communication, now we don't have a stalking case because we're starting with 2 instead of 1. And so you definitely want to build up that course of conduct as much as possible, as well as to have, again, just some accountability, to have that record for the offender. So I really encourage you to think broadly about some of those related charges that might be making up their larger behavior.
And some of this is really about trying to change the narrative. What I find often in courts is that there's this minimization that happens when we're talking about stalking and some of these other crimes, right? So boys will be boys, or when we specifically talk about what some people describe as revenge porn. I hate that phrase, but it's just so out there for the popular consumption that it's what most people think about. But we call it nonconsensual distribution of intimate images. I wonder why people have thought of a shorter name than that. Or image exploitation. There's a lot of well, just don't get on Facebook. Just don't take pictures of yourself. Those are really victim blaming narratives. And so as professionals, we need to make sure that we're doing our job also to change that narrative and to make sure that we're talking about it in an offender focused way. So this offender betrayed a trust, right? They asked for these photos, and that's really part of modern romance, right? So trying to normalize it, because frankly, it is, and especially nowadays. And so this offender misused technology, and that's affecting this victim's ability to live fully. So those are sort of the narratives that we need to be driving home, and we need to be challenging it when others say, well, just get off Facebook, because that's not, in reality, that's A, not fair, and B, there's just so much that we do online. It's impossible not to live a full, well, I don't want to say that because I'm sure there are people that do, but I know myself, it's really part of my life at this point. It's how I book plane tickets. It's how I communicate with family. It's how I share photos of my niece. So we can't be asking our victims to get off like that. We need to really change the narrative to make it an offender-focused one.
So one thing that's really critical when we're thinking about evidence is the context of the evidence. This is true in particular for stalking cases, but really across the board. And I think that when we're considering digital evidence and the admission, of course, we want to think about how do we get this in the record? How do we get this admitted? But a lot of the evidence on its own may or may not be that meaningful unless we consider the overall context. So just a quick refresher on stalking. Every state has a different stalking statute. So definitely happy to talk statutes with you whenever, but this is the behavioral definition that we like to use. And stalking is a pattern of behavior directed at a specific person that would cause a reasonable person to feel fear. So fear for what? Fear for their safety or the safety of others, or suffer substantial emotional distress. So we're looking at that physical safety as well as that emotional safety and their mental health. And so it's really that fear piece that's really critical, and that emotional distress. And that's tough, right? Because fear is very personal. What's scary to me may not be scary to you, and vice versa. It's really personal in nature. And a lot of times what's scariest to a victim may seem benign or even nice to an outsider. And there are so many behaviors that can be part of this pattern of behavior. So it's often called a course of conduct. So you probably already heard Jane and I use those terms kind of interchangeably: pattern of behavior, course of conduct. We're talking about the same thing. It's usually 2 or more instances required. In some states, it's 3 or more. And those are showing a continuity of purpose. So they're not just random bad things that happened, right? They are showing this person is trying to reach this victim, and they did it this way, then they did it that way, then they did it this other way. And stalkers, I do not mean this as a compliment to them, but they are very creative criminals. They use a variety of behaviors and tactics, often combining those that are crimes on their own and ones that are not. So if I'm stalking Jane because I'm the worst co-presenter ever, okay, maybe Monday I send Jane a bunch of text messages. Tuesday I'm angry Jane didn't respond, so I smash her car headlight. And then Wednesday I feel guilty, so I send her flowers. All of those are stalking behaviors. And so we have to be looking big picture at those behaviors that are crimes on their own and ones that are not. It's not illegal to send someone a gift, right? And those ones that are in person, like smashing the headlight, and ones that are online, like sending those text messages. And so sometimes we get very focused on often the most tangible thing. So that smashed headlights, we get it. We can see it. It's a property crime. We understand it. But these other things can be a little bit harder to understand and to connect. And a victim may or may not think to tell you and disclose, oh yeah, I know who smashed my headlights, and they've also been sending me weird packages. That may or may not occur to the victim to volunteer that information. So if a victim seems afraid, it's really up to us as responders to be thinking, could this be fear, and could this be stalking? Because when most victims experience this, they're not going to say, hi, I'm experiencing stalking. It is a crime. Here's the statute, right? If they do, that's great, but they're probably going to say something more like, my ex is harassing me, my neighbor's being weird, my professor has gotten creepy, I'm uncomfortable, I'm annoyed, I'm frustrated. And so we really need to be thinking, could this be fear, and could this be stalking? And thinking broadly about those behaviors. And I think Jane already answered this last one a little bit, but I'll hand it back to her for a little more on that.
Well, I love how you described it, Dana, because it's so true. That it's usually going to be sort of a mixture of things, right? So if this didn't work, I'm going to try this. And that's a reason why we don't tell victims, just change your phone number or just get offline, because that's not going to make the offender stop reaching out. It may actually escalate the offender's behavior. But the last part here about, can we charge separate? Yes, I like to think about stalking as an umbrella charge, and then all the other discrete crimes underneath it. So stalking is a really great tool for prosecutors because it allows us to talk about this continued relationship, where the law usually wants us to talk about the 5 minutes that something happened. So if we're talking about a domestic violence relationship and it comes to us because 911 was called because there was a violent act that happened, the courts normally are like, well, just only talk about this 5 minutes that this violence occurred. Well, we know that's not the whole story, and we know that's not an effective way to present something to a jury. So when we have this pattern of behavior, this course of conduct, oftentimes in the context of a domestic violence relationship, it gives us an opportunity to really tell that full story. So we've got this umbrella charge, and then we can charge the property crime, the violation of a protection order, the non-consensual distribution of intimate images. And then the jury, the judge, and the offender hear this and really get a sense of what this victim is going through. It helps recreate that reality of the victim instead of trying to sanitize it and make it seem like it all happened in a vacuum. So we can charge them all separately. There is no rule against that, and it's actually a really effective strategy.
It's great. Absolutely. And again, just a little more on context. We can try really hard to get, let's say this text message is admitted. Does it prove anything on its own? Not really. We'd have to explain the situation. So if a victim came to you and said, oh my goodness, I'm so scared. Look what I just received. Okay. There's really nothing here. So in this case, this was a victim who had dated and had an abusive ex-boyfriend, had been stalking her. Anytime she tried to see somebody new, he always found out. He'd been laying low for months. So she said, okay, great. I think I can finally start meeting new people. She hadn't heard from him. She leaves. She goes on a date with a new young man. She checks her phone after the date, and this is the message she got from that ex, from that stalker. And so clearly he had been watching her. He knew she was on a date and had sent this to let her know. And so with that context, it's really scary when we understand the story behind it. But if you just see a text saying he seems nice, we're like, see, the offender is friendly. What's the big deal, right? So we really need to ask the victims about what's going on to get a sense of why this evidence is meaningful and why this event was scary to them. And so some good things to ask are, what did that mean to you? Why was that important? What message did that send? What about that was upsetting? Has something like this happened before? And can you tell me about that? Had you heard those words before? Or, what happened the last time a text like this was sent? It said, oh yeah, then they went and slashed that person's tires. Okay, that's important context to know. And what were common threats made before you left? And how might this be hearkening back to some of those? Because basically, if a victim's afraid, there's probably a good reason. There is no better risk assessment than a victim's own fear. So even if it doesn't make a lot of sense at first, we need to remember that offenders are often engaging in specific behaviors that have meanings only understood between the victim and the offender. And so, for the classic example is an offender saying something like, I'll send you roses the day I kill you. Then the victim receives roses, is terrified. Everyone around the victim is saying, oh, how nice, you got flowers, right? And so we need to really be thinking about that context and asking those questions, whether the behavior is happening through technology or in person. Another helpful thing to do when we're thinking about evidence is not only think about the offender side of the evidence of what they did, but also look at how that victim's changed their behavior based on that stalking offender. Because again, stalking is about fear or emotional distress. And certainly fear and emotional distress are present when we're talking about domestic violence as well. And so we might have a victim say, well, I'm not afraid, because we as a culture don't generally love to volunteer when we feel afraid. You might hear that. I'm feeling annoyed, I'm concerned, I'm frustrated. But then ask the victim what they've changed as a result of that behavior, because they might say, I'm not afraid, but I changed my routes to and from work. I changed my phone number. I changed all my passwords. I bought a new security camera. And I bought something like a new thing. So, okay, to me, it's not you're calling that victim out or anything, but those are things you do when someone's kind of annoying you, right? That kind of investment and those accommodations that the victim is making for themselves are evidence as well that they are afraid that this person is really impacting their life. And so that can be helpful to support the amount of fear and or emotional distress that is happening.
And Dana, I just want to jump in here, because I felt like that as a prosecutor a lot of times. By the time the victim was in front of me, not only had the stalking been going on for a long time, but often they were also frustrated by the response from law enforcement and from prosecutors. And so when they came to me, they were presenting often as angry.
Mm-hmm.
And I would sit there and be like, oh, I'm not putting this person on the stand. The jury is not going to like this person. Not only that, but that person is kind of almost refusing to acknowledge that they were afraid. And so when I would say, oh, how'd that make you feel? They'd be like, I'm pissed off. And I was like, okay, well, that's not an element of the crime. And so those questions of those accommodations were literally how I would have to break that part down and start thinking about, okay, well, what did you do? And they would moved, changed jobs, all of these things. And they're not putting together the pieces because they're at this point so frustrated by the stalking and the system's response, frankly, that these were literally the most important things that I asked about, and to make that case something that I could go forward with.
That's great. No, I appreciate that. And yeah, just to add, just also witness corroboration, right? So even in addition to what the victims changed, okay, did they ask their workplace to do different things? Other locations, did they tell the daycare, hey, make sure this person doesn't pick up my child, that kind of thing. So just more to Jane's point of that corroborating that fear and kind of showing that distress, even if the victim themselves doesn't articulate it in quite the way that we would like them to go on the stand.
So we kind of already touched on image exploitation, or the non-consensual distribution of intimate images. This looks different in every state. I don't think we're quite yet at all 50 states having a law about image exploitation, but here at Equitas, we talk about it kind of in a larger sense, and it can mean the non-consensual creation, possession, or distribution of an image or images or recording of the victim, typically nude, engaged in consensual sexual activity, and sometimes also being sexually assaulted. So we put that all under how we frame image exploitation. And so the law is kind of keeping up with this. But in line with that challenge of sort of changing the narrative, one of the ways to do that is really thinking about the harm. And it is a unique harm in many ways because of things like Google searches and the way that you can, screenshot something. So the harm is potentially infinite and perpetual. And there's a Supreme Court case. It's actually about a victim of child pornography. And in her impact statement to the court, she said, yes, I was obviously abused as a child, but what lives with me day to day is I walk down the street and I look at people's faces and I wondered, have they seen those images? Because the images are so prevalent out there. And she really did a great job of sort of identifying that specific harm that continued to live because of the nature of the crime. And so I think we can learn from that as we present these cases, is really trying to get to the heart of that and really make folks understand that it is this unique harm and potentially lasts a lifetime. So how do we preserve and present this digital evidence? We're going to go through some strategies to do this, both from the law enforcement perspective, but also for victims to be able to do this themselves, because we know that oftentimes the first thing that happens, and especially a stalking, a course of conduct, if the first thing is a number of text messages, not necessarily is the victim running to the police with that, or they're not calling 911 with that. So unfortunately, victims often are being tasked with preserving their own evidence of being victimized. And that's unique to this type of crime. And it's just sort of the nature of that. And I know I see Sherry's things in the chat, and documentation is so important in figuring out how to do that really strategically and effectively. And not only are we doing a good thing for our cases, right? So now all of a sudden we have all this evidence, we can put it in front of the jury. Juries love that. And so the case isn't relying 100% on that victim disclosure and that victim testimony. Not only are we building those cases, but we're supporting the victims, because no longer are they sitting there going, this lives or dies with my disclosure, with my testimony. If you've ever worked domestic violence cases, you know the number one thing that an offender is going to tell the victim is, if you don't show up, it's all goes away. If you don't come to court, this all goes away. And so that's a lot of weight that is being put on the victims by the offender and by the system sometimes as well. So when we can say, you know what, it's not just you. We've got these text messages. We've got these tweets. We've got all this other evidence to support you. It could be really an effective way to lighten the load for the victims and survivors that are coming forward. So we can admit this evidence for a number of different reasons. Sometimes it is direct evidence of a crime. With intimate images, you've got the image, you've got it on Facebook, that's evidence of the crime itself. In other cases, it's more about providing context or corroboration. So context may be some text messages where before an act of domestic violence, there were these text messages where the offender was, asking where she was after work, talking again, repeatedly about some coworker, and that's the impetus of the fight, right? And so that's going to provide that context or that corroboration. It also can be admitted under what we call 404B evidence, which is other bad act evidence. And that, again, is a tool for prosecutors to sort of expand the story that we're telling. Don't limit us to that 5 minutes. Let us be able to tell the full story. And sometimes we can do that through other bad act evidence. So these are some of the law enforcement tools. It's really important for prosecutors and law enforcement to know this ever-changing landscape of Fourth Amendment law. I'm not going to do a deep dive here, but essentially, in order of protection, we can get certain information through a court order, through subpoenas. It's a lower standard, but when we're looking about trying to get information from a cell phone, from social media, anything that has content of communication, we're really looking at a search warrant. So you can't just send a subpoena to Facebook. You're only going to get maybe account information. You're never going to get the actual content of the account unless you've got a search warrant. And that's to protect all of us and our privacy. So these are lots of great resources for law enforcement. If they're not super tech savvy, there's a lot out there to help them figure out, okay, how do I serve a subpoena to Instagram? And so this is great resources. And I think we're making these slides available. So we'll just leave that there for you.
And just to add, yeah, all of these social media websites or otherwise, they all have a portal somewhere for law enforcement where a law enforcement officer can log in. You usually have to be law enforcement. You have to have an @law enforcement email address, and they will respond. Now, some platforms are more responsive than others. So, I've heard good things about Facebook or Instagram will send you to Facebook's portal. I've heard the cooler platforms are a little bit less cooperative, like Snapchat, TikTok. I'm sure at some point they'll become more cooperative and thus less cool, and people will move on to something else. So it's always a little bit ahead of us. But yes, like Jane said, to find, okay, well, how do I even try to get to these folks? And some of them are quite responsive and great. Yeah, definitely search.org is a great place that centralizes all that information.
So one of the things I wanted to talk about was this limiting scope. Equitas has an entire 90-minute webinar on safeguarding victim privacy in a digital world. So clearly I'm not covering all that material today, but we want to be thinking about what do we actually need for purposes of our investigation, for making sure we're, providing the defense with due process, with their discovery rights, but also protecting the victim. Because if you can imagine, anytime somebody's a victim of crime, like Dana's a victim of a crime, and the police are like, the only way we can investigate this, the only way we can prosecute this is if you let us download your entire cell phone. I'd be like, maybe not, depending, right? That's a really huge invasion. First off, my cell phone's going to be out of my hands. I can't have that for more than 5 minutes. And secondly, you're not getting just a couple of text messages. You're literally getting my entire life. And victims deserve that privacy, even if they've been a victim of crime. So we need to figure out how do we balance these two things. And so I think we have a little bit of a scenario here we're going to go through. So we've got George is charged with misdemeanor domestic violence after slapping Hannah. This happened over a fight that was over money because the rent was due. And so Hannah's phone has these text conversation, which is like, are you coming straight home? Don't forget the rent is due. And then George is like, don't piss me off. I've had a shitty week. Excuse my language. And so we want those text messages because they provide that context, which is so important. And it gives us sort of a insider view into what this relationship looks like. So to get those text messages, do I need to download Hannah's entire cell phone? No. And this is really great because these are things that we can do, anybody can do to preserve evidence. You know, it's simple. We all have, you know, screenshot technology. And so that's something that I often will share. Like, we don't need to do an entire forensic download. That's not required to put something into evidence. You really can just do a screenshot. And that can be a person doing it on their own phone. You can do a screen recording. You can take another phone and record yourself. I personally love the idea of doing screen recordings because frankly, it's just harder and takes more effort to tamper with recording rather than a screenshot. And so when you're coming into court, you've got a slightly better argument that this wasn't tampered with in any way because you're seeing a recording and you can sort of scroll through the phone, you know, a couple text messages before and a couple text messages afterwards, and you say this is the whole context, and that sort of makes everyone a little bit more comfortable with that. So that's kind of one of the pieces of advice. Not to say that a screenshot is not 100% admissible in court, it is, but I like the idea of the recording a little bit better.
Yeah, just to add, I've heard that judges in particular tend to really like the recording. Just if it was sent through something like Snapchat, it will notify the sender that you're taking a screenshot. So if you're like, what? I don't care about that, that's fine. But Snapchat is fun in that it notifies the sender if somebody takes a screenshot or a recording of what was sent, which the victim may not care about at all, or they might say that'll make them so angry, I can't do that. And so it's just something to consider. And just a quick thing on screenshots. I know it wasn't intuitive to me. You need to make sure you slide your thumb over so you can see the timestamp, and also they have to overlap. So it has to be text 1, 2, 3 screenshot and then text 3, 4, 5. You need 3 twice to show nothing happened between 3 and 4 that would change the context. So again, these things, for me at least, were not intuitive. And so if victims are capturing this on their own or you're working with them, make sure to just look a little bit closer at what will be needed for court.
So these are some of the things we've just talked about with the recordings, but victims can also download their own phone records, and oftentimes they can archive their own social media accounts. We would love to demonstrate that for you, but something like Facebook, if you go into your setting, it's pretty intuitive to find, and you can actually archive your own social media account. So that's another thing that if you're proceeding pro se or you're working with somebody that's proceeding pro se, that means kind of acting as their own attorney and investigator in this case. These are simple ways that they can preserve this, because we've definitely heard of cases where a victim survivor comes into court maybe for a protection order, and they basically just hand the judge their phone and they want the judge to just go through their phone, and most judges won't do that. So these are simple ways that somebody can record their own evidence.
And of course, that documentation is key. That's why so many folks are interested in VictimsVoice, right? So we also have an incident log on our website for that pen and paper version. So it can be great to do both, just so if there's any concern about, let's say, stalkerware on the device, to have that to kind of corroborate it. And so it's very succinct, that date, time, location, so many jurisdictional issues, particularly with stalking cases. And so most victims don't really understand jurisdiction. So they feel like, I called the police, and they did, but they called the police where they live and not in the city they work, or whatever it might be. And so to kind of help connect the dots, and really whether you're using this incident log or you're using VictimsVoice, the point is really that these incidents add up, right? But they only add up if we do the math. And something like this can really help us keep track. And even those incidents that were not individually criminal or reported, to make sure we really have all of it to build that course of conduct, to show the fuller story. And to add on to what Jane said about that, we don't just want those 5 minutes. Not only is that context important, but it's also can be very persuasive, because if you think about those, just like, stalkers do creepy stuff. I'm sorry if this is too technical jargony for everyone, but they're creepy. They do disturbing things. And so those details that haunt me and haunt you now, like, I'll send you roses the day I kill you, everyone's upset to hear that. That also impacts a judge and jury, right? That kind of bigger picture. And so it can be really effective. So again, just keeping track of everything as much as possible.
And this is another example that we often hear where there's some frustration. So Fran is seeking a protection order against her ex, Elliot. Elliot's been repeatedly tweeting threatening messages to Fran. Fran tells the court about the tweets, but Elliot's like, oh, I didn't do anything. And Fran wants to show the court the tweets from her cell phone. And the tweets are from EJR 1985 from the cell phone. So there's a couple of issues here. We already talked about the fact that most courts, even with pro se litigants, are not going to just, take somebody's phone and scroll through it. I've heard it happening, but we definitely don't want to count on that. But the other thing we often hear is, well, how do you know this was Elliot? Right? And so we're always challenged with trying to put the offender behind the device, behind the tweet, behind the text messages. And sometimes courts don't understand digital evidence. They don't understand how this works. And so it's really incumbent upon us to do some education and also to think about the fact that we can prove this through circumstantial evidence. So I once had a case where I really think that the defense attorney did such a good job sort of confusing the judge, who was clearly not tech savvy, that at the end of his argument, the judge was like, I'm not putting any Facebook in unless like Mark Zuckerberg is here to authenticate it. And I was like, okay, let's think about this again. And I had to re-educate the judge and think about, okay, we can do this through circumstantial evidence. If Elliot's initials are EJR and Elliot was born in 1985 and Elliot and Fran communicated through tweets during the course of their relationship, and those tweets were always from that same account, then we have a pretty good circumstantial case that that's Elliot continuing to tweet from that account. So what I often will say is, the admissibility, that's a very low bar to get something admissible to court. Now, a defense can always argue the weight of the evidence. They can always argue, well, maybe somebody else had Elliot's phone on that particular day. They can always make that argument to the jury, but to get it in front of the jury, which is just that admissibility bar, that's a low bar, and that really doesn't take very much. And so in this case, it should be easily done through just the victim's testimony of, hey, I know this to be his account. Those are his initials. That's the year he was born. I know we communicated through that account. It was always Elliot that communicated with me during, while we were together. And it's the same account that's now sending me these threatening messages. So those are the questions we're trying to ask ourselves. And we want to support victims, and we'll kind of run through these next slides because I know a lot of you on this webinar, this is what you do, right? You are supporting victims as part of that collaborative approach that incorporates law enforcement and service providers and the prosecutor. I mean, the key is really the victim service providers, to be honest. That's how I learned most of what I know about stalking, is from those folks that would share with me. Like at first I was like, why is the victim calling the offender every morning? I don't understand this. She says she's being stalked and she's calling the offender every morning. I can't possibly go forward with this. And the victim service advocate or victim advocate said to me, that's her checking his temperature every morning. That's how she keeps herself safe. She can read him that morning and she can go, okay, we're keeping everything under control. And that's a survival strategy that she has incorporated into her life. And all of a sudden that was completely reframed. And I was very confident going into court with that information and being able to ask those questions. So this collaborative approach is not only important to victims, but it's important to your allied professionals and all of you working together. And it helps things like making sure the victims have tech safety planning, which not every victim service professional knows about. I think the next slide talks about the number of victim service professionals that don't really understand the risk factors related to technology. And maybe we're still hearing about folks that are advising victims to just disconnect. And we know that's not either realistic or safe.
Yeah, and I know we're running low on time here, but just to play that out for a second, stalkers are persistent. So, and so are domestic violence offenders who are engaging in this kind of abuse. And so, if I'm stalking Jane, I keep calling her, and eventually she's like, I'm so over Dana, I'm going to change my number. And so I call and I get that, oh, this number's no longer in service. Am I, the stalker, going to be like, oh man, I guess I'll stop stalking Jane and become a productive member of society this day? Like, No, right? Because I'm stalking Jane. I know where she works. I know where she lives. I might actually escalate my behavior. And so not only is it not really fair to ask victims to do that, it's also just not strategic a lot of the time in terms of the victim's safety. Also, when you think about disconnecting or changing an account, you want to think about the evidence as well, because sometimes if they, let's say, shut down that account, it might be harder for the victim to get their side of the evidence or the records of that, you know, their conduct on that. So you definitely want to think through all of those things. Maybe they suspend the account or make it invisible or change their password or whatever. And so that you don't lose all the evidence as well. There's some good resources here for more information. Safeguarding privacy, the Something Can Be Done, which I really love, the Cyber Civil Rights Initiative, National Crime Victim Law Institute, excuse me. And we'll send all these to you. And on the Spark website, we also have a resource page that includes some information on technology and stalking. As you could hear, Jane is passionate and a wonderful speaker on image exploitation. So there's some really great resources here just for prosecuting that specifically. And the Prosecutor's Guide to Stalking, also available on our website. Stalking, very undercharged. When it is charged, that charge is often not picked up. These offenders are not being held accountable. And it's not right. Stalking is criminal, it's traumatic, it's dangerous, it's prevalent, and there's absolutely more that we can do. So going forward, we hope that folks keep up to date with technology and trends. And the good news is we can help with that. Here at Spark, we offer a training on the use of technology to stalk. So we can talk about, you know, what is this? How are offenders misusing it? How do you collect evidence on it? How do you safety plan around it? Use digital investigations to hold offenders accountable. So really connecting folks with those resources and tools to make sure that they are doing their due diligence and really doing that investigation. And of course, collaboration, right? That we don't want to work in a vacuum. Easier said than done, but let's get together to maximize victim safety, engagement, as well as privacy and weigh those different factors. This is my contact information. So again, for further training on stalking, the use of technology to stalk, investigating stalking, sometimes Jane and I train together, sometimes separately. Spark is for multidisciplinary professionals, so please feel free to contact me, and I'll stick around in the room after that I know we're about to be transported to. So here's my information, and here's Jane. And her information. So I just want to thank you all so much for your attention and for all the critical work that you do. I know it's easy for us to sit here and say, do this, think about that, consider this, but you're the ones really on the ground doing the work, keeping victims safe and holding offenders accountable. All of it's easier said than done, and I totally understand that. So thank you so much for the work that you do and for tuning into this. We hope it was helpful. And with that, yeah, we'll go back to the other chat. So I'll hand it back to Sherry.
All right. Thank you. Wow. Tons of great information. And so we had a question in there. The question was, what was the phrase you used to describe intimate images? And then Jane answered in the chat, non-consensual distribution of intimate images. Okay. And are there any other questions? Go ahead and put those in the chat.
I did want to, I saw someone in the chat, this wasn't quite a question, but say they have issues with spoofing. And so I wanted to just speak to that really quickly if we have a second.
Yep.
So spoofing is when someone makes a phone call or sends an email, it looks like it's coming from somebody else. It's very easy to do. You can do it cheaply or for free, very effective. And so in terms of evidence with that, there's different ways to look at that. And Jane, I'm sure will have some additional insights. But again, easier said than done. But ideally, you'd want all three devices. So let's say I'm stalking Jane. I know she won't pick up the phone for me, but she's going to answer Sherry because Sherry's cool. She's the victim's voice lady, right? And so I changed my phone number. It looks like Sherry's calling. Jane answers the phone. It says Sherry on her phone, but then it's me. Ha ha, I'm the evil offender. But then Jane wants to prove it, right? But she can't because when she looks at her own phone, that call history will always show that Sherry called. If she misses a call and calls back, it's going to call Sherry, not me. So what is she to do? Well, ideally, you would have all three devices, right? Which requires, I know, again, easier said than done. But so if you look at Jane's phone, it's going to show Sherry called. You look at Sherry's phone, it's not going to show that Sherry called because she didn't, right? You look at my phone, I'm the offender, it's going to show that I called a spoofing service. So sometimes you can just call that number back and you'll actually get a voice greeting that's like, welcome to the spoofing service. So you can record that. That's pretty compelling evidence. Increasingly, though, they're generating random numbers. And so, but it's still like, okay, for the same time and duration, I, the offender, called a number I've never called in a random state while Jane was receiving the suspicious message. And so it just doesn't add up, right? So when you line it up, those 3 phones, for example, in this calling example, you see that it doesn't work. Also, these services are not free. I know because I used to do one as a sample and now I'm supposed to pay for it. And so even if you have access to the offender's either app downloads, if they downloaded an app, that's how quite a few of them are doing it, or some is just through a website. There's also a tangible spoof card you can buy, like an old international calling card. It works the same way. So if you look at their financial records, it may not say, you know, payment to spoofcompany.com or whatever. But if you dig a little bit, you will find that they did pay for it. And that can be compelling as well. Also, sometimes they give themselves away by something that they say or do, or sometimes they do identify themselves. A lot of these spoof apps have features where an offender can change their voice or add background noise. So a victim might say, I got this weird call. It sounded like it was from an amusement park. It was from some lady, and my offender's male. That might still be the offender, just using a few voice controls. And so you want to think broadly about how they might be using this kind of technology. And if victims are telling you, I'm getting these weird calls, or it doesn't make sense, or people are saying I'm calling them, that might be spoofing, and there are ways to prove it. So,
and you can usually charge identity theft with those if they are using a real person. So we had a case in Miami where the offender was, they had been dating for a while, so they had like friends in common, and so the offender was calling the victim using all of their work colleagues' names and phone numbers. And so for every time that they used that, we got to charge an identity theft charge. So another creative way to do it.
Nice.
Okay. Are there any other questions? Oh, I see a couple of questions in the Q&A section. Let's see.
I actually answered one incorrectly, I think. Somebody was asking about if some of this evidence is in another language. Clearly, during an investigation, and when you're doing those interviews, your survivor can translate those for you and explain to you what's going on. But to enter it into court, you'd have to have a certified translator do that.
Yes, and I will say too that from our perspective, if someone is going to be documenting and they speak a different language, have them do it in their native language, because if they use a translator like Google Translate, it doesn't always translate appropriately to what they were trying to express. So have them document in their native language and have a certified translator work with the victim to have that translated.
And honestly, my very first trial I ever had as a baby prosecutor was a stalking case that involved different languages. And it became very, very important that I actually used a translator with the same Spanish dialect, because the threats that were being used were idioms that didn't translate. So I had a victim and survivor that were both from Colombia, and the original translation was somebody that was from Cuba. And it was a literal translation of a very common idiom that was very threatening. And I didn't come through the translation. So
yeah,
pro tip there, get the same dialect as well.
Yes. Excellent. All right. Jane, Dana, thank you so much on behalf of the audience and Victims Voice. We'd like to thank you for today's Lunch and Learn. For those of you who have further questions about the material covered today, or whose questions were not addressed in the Q&A portion, please feel free to contact Spark or Equitas directly. You may also let us know in the chat that you have further questions, and I will make sure that someone from Spark or Equitas is able to reach out to you directly. You will receive a survey pertaining to this event. Doesn't everybody love a survey? Your feedback is really crucial to our future programming, so please take a 5-minute coffee break and fill out the survey. I promise it won't take longer than 5 minutes. Upon completion of that survey, you will be provided a link to the resources and the on-demand recording. And
I've never had so many resources as these two ladies have provided, so you guys are in for a real treat. You're going to be scrolling on the webpage. And finally, our upcoming Lunch and Learn programs, as shown on the screen, will be centered around the intersection between healthcare and domestic violence. Both programs will be sponsored by the Academy of Forensic Nursing. If you'd like to be notified about our upcoming events, you may subscribe to our event-only mailing list on our website at the URL shown here, or subscribe to our channel on YouTube and you'll automatically get an alert when the on-demands are made available. Now, let's move back to the networking hall for continued networking and